A transcript rejected at the courthouse door. That's not a hypothetical. It happens to legal teams every year, sometimes on the eve of a hearing, sometimes mid-deposition, and almost always because someone assumed a transcript was court-certified when it simply wasn't. In legal proceedings, the word certified carries specific enforceable meaning. It's not a quality label, it's a legal designation that determines whether a transcript can be admitted as evidence, used in a deposition, or entered into the official record of a court. And what makes this genuinely complicated is that certification requirements are not uniform across the United States. Each state has its own rules about what a compliant transcript looks like, who can certify it, what language must appear on the certification page, and how the document's chain of custody must be documented. A transcript that meets the standards in California may fall short in Georgia. One that's fully accepted in New York may trigger an objection in Texas. For legal professionals navigating multi-jurisdictional matters, that patchwork of requirements creates real exposure. So what does court certification actually mean? At its core, a court-certified transcript is one that has been prepared to meet the evidentiary and procedural standards of a specific jurisdiction, with a certification statement attesting to the accuracy of the transcription and the qualifications of the transcriptionist or certifying party. Some states require the transcript to include verbatim notation of every utterance, including non-verbal sounds and speaker identifications formatted in a specific way. Others have requirements around timestamps, page formatting, or the inclusion of a signed affidavit. The stakes are straightforward. Without proper certification, opposing counsel can challenge the transcript's admissibility. Judges can exclude it, and the work your legal team built around that document can be undermined entirely. This matters most to the professionals who live closest to these requirements. Litigation attorneys who manage depositions across multiple states face this constantly. Paralegals responsible for organizing and submitting evidentiary materials need to know that every transcript in the file meets the standards of the jurisdiction where the case is being heard. Court reporters who provide transcription services need compliant formatting to protect their professional standing. Litigation support professionals, coordinating large discovery projects, often manage dozens of transcripts simultaneously, sometimes spanning several states, and a single non-compliant document can stall an entire proceeding. Consider a few specific scenarios. A law firm handling a product liability case with witnesses deposed in 3 states needs transcripts that meet the court rules of each state individually. A criminal defense team preparing for a federal hearing may need transcripts of recorded law enforcement interviews that carry a documented chain of custody, proving the audio was not altered, and the transcript is a faithful representation of the original recording. A corporate legal department responding to regulatory proceedings needs certified transcripts of internal interviews that can withstand challenge from opposing counsel. And a solo practitioner in a smaller jurisdiction may simply need to know that the transcript they're submitting meets the local court's formatting rules without having to research it themselves. In each case, the need is the same: a transcript that is accurate, verifiable, and accepted by the court receiving it. This is exactly the problem Ditto Transcripts was built to solve. Ditto Transcripts is a US-based transcription services company that provides court-certified legal transcription accepted in all 50 states. That scope matters because Ditto Transcripts has done the work of understanding jurisdiction-specific requirements so that legal teams don't have to. The transcripts Ditto Transcripts produces are formatted and certified to meet the procedural standards of the state where they will be submitted. Whether that's a deposition transcript for use in a state court proceeding or a certified recording transcript for a federal hearing. Ditto Transcripts supports depositions, hearings, and legal proceedings with documented chain of custody protocols. That means the path from original audio to final certified transcript is traceable and defensible. All staff at Ditto Transcripts pass fingerprint-based criminal background checks, which is particularly significant for legal and law enforcement work where the integrity of the personnel handling sensitive material is not optional. Ditto Transcripts is also CJIS compliant and HIPAA compliant, meaning it meets the security standards required for law enforcement records and protected health information, 2 categories that appear regularly in litigation. Beyond legal transcription, Ditto Transcripts also provides law enforcement, medical, academic, and general business transcription services. making it a single-source solution for organizations with varied transcription needs. What this means in practice is straightforward. Attorneys submitting transcripts don't have to second-guess whether the format will trigger an objection. Paralegals building evidentiary files can treat Ditto Transcripts documents as submission-ready. Litigation support professionals managing multi-state discovery can rely on consistent certification standards across every jurisdiction in a matter. And court reporters working with Ditto Transcripts can offer clients a documented, defensible product. The rejected transcript scenario at the start of this conversation becomes avoidable, not because the process got simpler, but because Ditto Transcripts handled the complexity behind the scenes. Legal teams who want court-certified transcripts, they can submit with confidence. In any state with full chain of custody documentation, we'll find that Ditto Transcripts has already built the process to make that possible. Learn more at www.dittotranscripts.com.